Hi, everyone. My name is Ruby Powers with Powers Law Group, and today we're going to talk about the lesser known immigration alternatives for when people might have been told that they were ineligible or didn't have a form of relief or something that they could apply for here in the United States. I'm board certified. There's only about less than 200, I believe, board certified immigration attorneys in Texas. And that's a special test and certification after practicing for 5 years or more. And with Powers Law Group, we're a full service immigration law firm. We're located in the Heights in Houston. We also have a location in the Woodlands. But we have a global reach because it's a federal law. So if you need help with your U.S. immigration matter, you can find us and we can help you anywhere in the world on U.S. immigration matters. I also an author about law practice management and a professor about law practice management at South Texas, and just wanted to share this presentation because so many times people go to get a consult and they say, oh, you're not eligible for anything, but sometimes there's these little rare options that exist, and so I wanted to explore those with you. And thing is, immigration is always changing, so it could be something that opened up that created this whole domino effect of another possibility. So, just one thing that some people don't think about is there is the T visa, and the T visa is a trafficking visa. It could be for human trafficking, it's for labor purposes or sexual reasons. And so sometimes people think it's only sexual, but it's actually could be labor trafficking as well. So there are ways to get to be screened for this and to see if you'll be eligible. There's none of the visas are capped every year, so the processing times are way less than the U visa, and the visas are available every year. And it does give you a pathway to including spouse and minor children, unmarried under 21, as well as a pathway to a green card and other waivers. So the T visa is something that is underutilized. I mean, it's definitely an unfortunate visa, just like the U visa, but it is something that you definitely need to be screened for. The other one is the U visa, which is the victim of certain crimes and who suffered mental and physical abuse and have been helpful to law enforcement or government officials in the investigation or prosecution of the criminal activity. And that whole sentence is really full of all the requirements because it is certain there are just certain crimes, and you have to be helpful and you have to demonstrate the mental physical abuse. So this is an option. Unfortunately, there's not enough visas available for everybody who's applying. So currently the word is that it's taking maybe 15 years to get a visa for the people who applied now, but people who applied in 2000, I believe 8 or so, are starting to get the visas available now. But the beautiful thing about it is you can get work authorization with the deferred action work authorization after sometime after applying, if once that is found. And you also can waive a lot of different inadmissibilities. And it also can include spouse and minor children under 21. So it's something to look at. S visa is one we haven't handled one before, but it's a special visa in which law enforcement can provide that as a witness or informant in a criminal investigation, but it is something to ask about with law enforcement if you find yourself in a situation like that. And M is something like a full-time student. It could be something like a pilot, for example, certain types of student types of visas, but that are not an F. But F is the one that's more common, but M is also one that could exist as well. Now, adjustment of status, having really, it's very rare to be able to be approved adjustment of status if you have an illegal or abnormal entry, but there are some exceptions for that. One of them could be parole in place, military parole in place specifically, and so this could be because you can demonstrate that you're the spouse, widower, parent, son, or daughter of an active member of the U.S. Armed Forces, individual in the Selective Reserve or Ready Reserve, or military veteran. So if you are this meets your requirement. If you meet the requirements of this military and parole place, you can apply with that proof to the local field office. So in Houston field office, for example, and then they will review everything. If they agree and approve, then they will give you a document, a parole document, a piece of paper that says yes, we agree you have military parole in place for 1 year. With that, you can apply for work authorization, and if you meet all the other requirements, you could use this as a parole entry for your adjustment of status if you have a immediate relative. So that can really open a lot of doors, and we've really had a lot of great success with that. In terms of new changes we were talking about, some of these new changes are creating like a beautiful domino effect to other eligibility. One of them is the family reunification parole process. In July, they began issuing family reunification parole process for Colombia and El Salvador, Guatemala, and Honduras. So basically, they had to have an I-130 that it was available by invitation only for those who had an I-130 filed on behalf of a principal. And this was a way to speed up the process of them being able to come here into the United States. There's a lot of these programs that are being popping up, so it's great to have a consultation to see if you're eligible. The other, an oldie but a goodie that it's definitely not outdated yet because they're still benefiting from it, is 245I. And so the gist of it is that you would have to meet all the requirements. There's different versions of this. So one of them is that you are physically present on December 21st, 2000, and that you are the beneficiary, or you were underneath a petition of some sort in the past of the labor certification, an I-130 or I-140 that was filed on or before April 30th, 2001. And it needs to have been approvable at the time of filing. It was sort of hard to explain this, but basically, to adjust status, you generally have to be admitted, inspected, or paroled, and you need to have a visa available, and you need to not have worked illegally. Well, the 245I can act as your admitted, inspected, or paroled, and waive that requirement, and it can also waive the issue of working illegally, but you still would need a visa available. So it could be used 245I from an old petition that somebody filed for your mom, and you're a child at the time and unmarried, and you can use, now you have a 21-year-old child who's a US citizen, and you combine those two forces together and get your green card. So many people are eligible for this, but they don't know it. And definitely have a consult. And that's why I often find in the consultations, when people don't apparently look like they're eligible for something, I ask a ton of questions, because they might be eligible for something, especially, or someone in their family might have petitioned for them. And the other thing is, there's some other requirements. This is sort of like a general summary. If you had the petition before sometime in 1996, doesn't have the same requirements to have been here on December 21st, 2000. So it depends on when the petition was filed. Now, Maraquilantan is another oldie but goodie, where if you can prove that you were waived in at the border, that you were inspected, admitted, that you could count that as your admitted, inspected, paroled requirement for 245A for adjustment of status. But you have to explain it a lot of detail, write an affidavit, have affidavit of whoever was in the car with you traveling, however it happened, about that it's more likely than not that this actually happened. And sometimes it happened so long ago, and the people that weren't around don't usually want to admit to all this. So I don't see this very often, but it is something that does exist. And so it's something to explore, especially if this is what happened to you or somebody that could benefit from this process. So moving on. So the Western Hemisphere is definitely a lot older. And so it's a type of a priority date that was part of a savings clause in 1976 and preserved the old priority dates for immigrants who qualified and registered for immigration before January 1st, 1977. I guess the best way to say it is this still exists. Some people are eligible, they don't know it. And some of the questions to figure out if you might be eligible are, did you ever register to immigrate or apply to immigrate before 1977? Did your parents ever register to immigrate or apply to immigrate before 1977? If you're married, do any of these questions apply to your spouse? And so those are the things to consider. Again, A lot of times with these older provisions, people already have established their status, and so we don't think about them that often, but it's something to consider, especially if um, we can't think of anything else, and maybe they do qualify for it. Now, another one of those is registry, which is even older than that one. And I've done one in my whole 15 years. But because the other thing is most people have already gotten their status already cleared up, but this is one where a person thought they were US citizen and they found out they weren't, and then we had to use this to help clean things up. But anyway, this is that you had to prove that you were here in the United States on January 1st, 1972, with the ability to apply for a green card. It's such a hard standard to be able to prove you've been here and you don't have a status. But luckily, the individual that we were working on had worked almost at the same place for a very long time, so it made it easier. But you have to show proof that you, it's almost like DACA, where you have to show proof that you lived in the US with so many documents per year. And it actually was, you don't have to prove that you entered legally, and there's actually a lot of the provisions about the crime, criminal or other inadmissibilities are not very strict. So there's also talk, not to get all nerdy on us, but like if we could just move the registry date to, like, I don't know, January 1st, 2020 or 2010, I don't know, like a whole lot more people will be eligible for a green card. So this is an oldie but a goodie as well. Cancellation of removal is something we consider. This is, you have to be in court, and there's like three pronged. You have to have extreme and unusual hardship to a U.S. citizen, legal permanent resident, spouse, or parent, or child, and what would happen to that individual, why they can't relocate to your home country, and why they can't live without you. And then you also have to show good moral character and that you lived here in the United States for at least 10 years. So that's where you want to show your taxes and other evidence. The good moral character and the 10 years, there's a lot of little fine print in that. I find that these cases drag on for a long time, and sometimes the qualifying relatives age out of being needed, and the hardship can start disappearing over time. But you also have to be in court. Remember, this is defensive, but this is another potential option because you can get work authorization while it's pending. Sometimes people are citizens, they don't know it. So, acquisition of citizenship refers to when a certain foreign-born children acquire citizenship automatically by virtue of being born to parents who are U.S. citizens. So it is possible to be born in a foreign country and be a citizen at birth, but not realize it. So I love citizenship matters. I love talking to people. I love helping people figure this out. Every situation can be very different. So it's really important to know so many dates, when people got married, when people were born, when people moved did this, how long did they live here before you were born? It's really quite crazy. But anyway, another one is derivation of citizenship. A person could derive citizenship. A child who become a U.S. citizen before the age of 18. So this was also clarified more under the Child Citizenship Act, because there was a lot of situations where people thought the kid was a citizen, but they weren't, and they needed to clean this up. So a child born abroad who was not a U.S. citizen at birth automatically, like the slide we had, can acquire U.S. citizenship when all the following conditions are met on or after February 27, 2001. So, at least one of the parents is a citizen, either by birth or naturalization. The child's in the U.S. with that parent, U.S. citizen parent. That child is a legal permanent resident. The child's under 18 and is not satisfied merely by filling the N-400 before the child 18. It means the parent must complete the naturalization interview and oath. But the parent has to be completely a citizen by the time the kid turns 18. So there's been times where we were sort of in a rush to make sure this happened, and just because of processing times, it didn't make it. But anyway, this is really critical to consider. It also saves a lot of money if the kid becomes a citizen before they turn 18, because then they don't have to naturalize and they can just apply for a U.S. passport or certificate of citizenship. So this is just a chart to show how complicated things can get. Sometimes when somebody can't come to the United States because they have some inadmissibility, another option could be a non-immigrant visa and a non-immigrant waiver. And so matter of Harenga, it has three factors: the risk of what's the bad thing the person did that made them inadmissible, And the other one is, well, the risk to society is the first one, the seriousness of what they did. And the third is that why they want to come here. So there's some people who, like, for example, have misrepresentation finding, even though they dispute that, but they don't have a qualifying relative, they can't come in. Some people have like a DWI or some alcohol issue, and they need to have a non-immigrant waiver to get in on the tourist visa or student work visa. So anyway, these are some things to consider. And well, we are at the conclusion. I tried to explain several unique things. I mean, I guess I sort of sped talk through that, but we covered a lot of them. There might be one or two that I didn't really talk about, but including like with DACA being able to get the advanced parole and then being able to adjust status. That's another good one too. But I think a lot of people know about that one. So I guess in conclusion, if you ever are told that you don't qualify for something, what I would say is have a consultation, probably with a couple of different attorneys that have a good reputation and experience, like us, for example, and just make sure that they have all the documents and information provided. If you think any of this stuff applies to you, bring this type of stuff up, because maybe they're not asking that on a regular basis, or with your existing attorney. And there could be a possibility that you're eligible for something that you didn't know about, as well as things change on a regular basis. So I usually tell people who aren't eligible for something at the first instance of consult to have a regular consult once a year, or if you hear something big in the news or you learn something that might make you eligible. So thanks for watching. We'll be back again next week with unlocking opportunities, work authorizations, and decoding the asylum clock. Again, my name is Ruby Powers. We have a few attorneys here with Powers Law Group. We have a location in Houston and the Woodlands, and you can reach us at 713-589-2085. Thanks again for watching, and feel free to reach out.